Good morning, everyone. This is Justinian Lane of Justinian Associates, and I have with me lead attorney Erik Walker today. And we're going to talk about a pretty important victory that he just had on an appeal before the 11th Circuit Court of Appeals on a trans-vaginal mesh case. Erik, can you talk a little bit about what the case was about?
Sure. By the way, the 11th Circuit refers to a federal appellate court, the United States Court of Appeals for the 11th Circuit. There are only a few federal appellate courts in the country. The appeal stemmed from a dozen cases involving a trans-vaginal mesh product called OB tape. For those unfamiliar with the product, trans-vaginal mesh is a product that is implanted into a woman's vagina to essentially prop up the bladder to treat urinary incontinence. These devices, a number of them, particularly OB tape, were just terrible devices, and the companies knew they were bad devices before they were ever implanted into the first women. They were devices that were destined to erode, they were destined to cause infections, they were destined to break apart, to move around in the body, to basically lodge themselves into internal organs, and that's what happened to a number of these women. Many women experienced severe pain, both pain regularly during the day and certainly pain during sexual intercourse, and many other health problems, infections, secretions, just all sorts of, a myriad of different difficulties, to the point where the mesh had to be surgically removed from the women, but they couldn't get it out. And many women have had a half dozen or more surgeries, they call them explant surgeries, to remove the mesh, and still they can't get all the mesh out, and the women will be in pain for the rest of their lives. A number of women filed suit over OB tape cases. These are suits that ended up in a multi-district MDL proceeding, MDL as we spoke about earlier on some of these videos, all of them before one federal judge in Atlanta, Georgia. The judge determined that for women who had known of the mesh eroding for a longer period of time than the statute of limitations governing her case allowed, that those cases would be thrown out or dismissed. In other words, you have a certain amount of time to file a lawsuit under any state law. And if you exceed that time limit, your case is subject to dismissal. In most states, the time limit begins when a woman or any plaintiff knew or should have known of both the injury they're experiencing and the cause of that injury. In these cases, the judge determined that these women knew of the injury and the cause of their injury when they became aware that the OB tape had eroded in their vaginas. What the Court of Appeals just ruled, and what happened was the judge dismissed a number of these cases on summary judgment. 12 of them were consolidated for appeal. I was hired by a number of different plaintiffs' firms representing women in the trans-vaginal mesh litigation to represent their clients on these appeals. And I briefed, meaning I wrote the brief and argued to the 11th Circuit these cases. And what the 11th Circuit held is that the judge was wrong, that the statute of limitations, the time limit for these women to file suit, did not begin when they knew the mesh had eroded, but rather when their doctors had informed them that the mesh had a causal connection to their injuries. In other words, the mesh might have eroded into their vagina without them knowing that any problem with the mesh had anything to do with their injuries, had anything to do with the infection they were suffering from. It may have just been symptomatic. And the court said it's not just a connection between the injury and the mesh that begins the statute of limitations, that begins that time limit for women to file suit. It's knowledge of a causal connection between the mesh and the injuries. And the judges determined that it was for a jury, not the federal judge, to decide when these women became aware that the OB tape had a causal connection to their injuries, such that the deadline for them to file suit began. Consequently, the Court of Appeals sent all of these cases back to the federal district judge to continue them in the trial process. And we're hoping that that will happen with other cases on appeal that involve a similar ruling by the court.
Now, one of the things that was very interesting about this to me is when you discussed with me you were going to be working on these cases, that the other firms from around the country wanted help on this. This didn't look like a very easy appeal, did it?
No, a number of firms tend to hire me to handle appellate matters when it looks like the appeal may not have a great deal of chance of success. We thought we should have success in these appeals because we thought we were right on the law and we thought we were right really on how the law should be applied. But it's very difficult to expect federal courts of appeals to reverse MDL court orders. You have to understand that an MDL court is a court that is charged with presiding over hundreds and sometimes thousands of lawsuits. And there's a natural tendency, I think, on the part of federal circuit court of appeal judges to give MDL courts a lot of deference because of the ominous task that they're charged with performing in having to manage so many cases. Technically, on an issue of law, like a summary judgment on statute of limitations, no deference is owed to the district court. But psychologically, there's a belief that appellate court judges might give the MDL judges more deference than they're entitled to. Well, the 11th Circuit here proved that they were going to follow the law and not give the judge any more deference than he was entitled to. So it's not that it looked difficult to win the cases on the merits, just the circumstances of this being an MDL court order on appeal made it such that we were concerned that maybe it would be difficult for a court of appeals to reverse. And I'm very pleased that the 11th Circuit proved that not to be the case.
It's also an interesting case because it involves a federal interpretation of state law, the discovery rule, which is, as Erik talked about, when you're injured, you have a certain amount of time to bring a lawsuit following either when the injury occurred, if you know what the cause was. Like in a car accident, if you get a broken leg, you know that the car accident caused your broken leg. In this case, as he was discussing, the women knew that the mesh was eroding and causing them problems, but there could have been other causes of that erosion. And I think you talked about there was one plaintiff in the case where she thought it could have been her diabetes. Is that correct?
Well, in fact, her doctor told her he thought her diabetes may have caused the erosion of her mesh.
And Erik had mentioned the concept of deference when the appellate court is going to defer to the lower court's interpretation of the law, but there's no deference for facts. And in fact, if it is a fact issue, the court is not supposed to rule on that. Is it right? It goes to the jury.
Yeah, essentially, what happens in a trial set case is that the jury decides all issues of fact, the judge decides all issues of law. In the end, the judge will decide what the law is, instruct the jury on what the law is, and the jury will decide the fact questions based on the interpretation of law the judge gives. If the judge concludes that there really is only one reasonable interpretation of the facts, that no reasonable jury could come up with any other conclusion besides the one that the judge has, then the judge will issue what's called a summary judgment, in which the judge concludes that reasonable minds could not differ on this set of facts. This is the only conclusion they could reach. And then he'll take the case away from the jury and rule himself. And that's what happened here. The Court of Appeals is supposed to do what we call a de novo review of that. That means they're supposed to look at this on their own without giving any deference to the district court's opinion, because the district court, in essence, took the case away from the jury. And the Court of Appeals should only allow such a decision to stand if it agrees with the judge, based on its own independent review of the evidence, that reasonable minds could not differ.
And typically, or maybe if not typically, at least often, the appellate courts will side with the courts below. As Erik said, some of it is psychological. The courts are kind of on the same team, and they try to look for reasons to affirm or uphold the opinion. And it's pretty unusual in an MDL proceeding because that's the special role that's given. Erik's had a lot of success in appeals relating to MDL issues, and firms from around the country have sought out his expertise on this. So we're very happy to have been able to help out in this, and there's a chance that this decision could be used by other attorneys to help similarly injured people. Can you talk a little bit about how that works when an appellate court makes a decision, how that affects other cases, even not people who are party to that case?
Well, appellate court decisions are generally considered precedent for the courts within the circuit that's deciding the appeal. Here, the 11th Circuit, which presides over Georgia, Florida, various other states. Unfortunately, this decision was not designated for publication, so technically it's not to serve as binding authority on the courts in those states. We may very well file a motion with the court to publish the decision, which would give it precedential effect. But independently, courts tend to look at written opinions by other courts in deciding issues on their own.
And it's some of the interesting quirks that you don't really learn about until you go to law school. Erik is mentioning if an opinion is published or not. And if an opinion is published, then it becomes binding and all of the courts below have to follow it. If it's not published, they can look at it and consider it. And because of some of the issues in this, as Erik said, he may file a motion to see if the court will change its mind and designate this for publication. And if the court decides to do so, then that opinion would apply to every court in the 11th Circuit, all of the district courts below in the 11th Circuit. We hope that they will do so. And even if they don't, this will still be absolutely binding on all of the OB tape cases that are pending in that MDL. About how many cases do you think that is, Erik?
It is, well, it's binding in the sense that I don't think the judge would deviate from the ruling. But there are several hundred, I don't know how many are left. There were originally, I believe, several hundred cases in the proceedings. There aren't that many left, but there are a number of them coming back now as a result of this decision.
And if the court had ruled the other way, those women would not get their day in court. Their case would be thrown out.
No, these dozen women that were part of this appeal and several other women who have appeals pending to the 11th Circuit would have probably certainly these 12 women would have had their cases over, and the other women would likely have as well.
How do you think this is going to affect it? I know this is just pure speculation. Do you think that these cases are going to go to trial, or do you think OB tape is going to settle? Or
the defendant has been settling with the plaintiffs in most of these cases up to now. These cases did not settle because the defendant felt that they would get them dismissed on the statute of limitations, which they ultimately did. Now that the Court of Appeals has said no, these cases are not subject to dismissal on the statute of limitations, I believe that it's likely they will all settle.
And that'll be wonderful for those women if the cases settle and they're able to get some compensation. Our firm is handling a number of the trans-vaginal mesh cases, and as Erik said, these poor women, ranging in age from some surprisingly young to some rather old, are having terrible complications and pain. I know we're representing one woman who is just terribly embarrassed that due to the way this has worked out for her, she has to stand whenever she urinates. And she's an older woman. She's somebody's grandmother, and I can't imagine what that must be like for her. And the products, as Erik was saying, that these all appear to have been really just bad products. I mean, what are your thoughts, Erik? Should these products have ever come to the market?
They should. Most of them should never have come to the market. The companies knew before they ever introduced the products that they had a tremendous risk of infection, erosion. They knew that the materials that the product were made of were going to be materials that migrated, that they knew that they didn't have sufficient porosity. They knew a number of things that resulted in knowledge, essentially, that exactly what is going to happen, the mesh having to be removed from these women's bodies, would have to occur. Whether they knew that it would be almost impossible to fully remove the mesh from the bodies and that these women would be experiencing pain for the rest of their lives, I don't know. But they knew that these would be products that were going to cause severe injury and pain to our nation's grandmothers, essentially, and they went ahead and sold them anyway, because there's a lot of money to be made.
And these are products that they're basically embedding inside of tissues such that there's no practical way to pull it out without causing even more harm?
Well, that's right. They're designed to prop up the bladder, essentially, and thereby prevent urinary bladder incontinence. The problem is that they then end up disintegrating, eroding, and they end up lodging themselves into the organs and into parts of the body they weren't intended to be in. They extrude from the vagina. Many of our clients literally have pieces of mesh that are protruding from their vagina because it's eroded. And both they and their husbands report it virtually impossible to have anything other than painful sexual intercourse.
And this was a product designed to treat urinary incontinence, you said? And that typically would happen, was it childbirth would cause some problems or sometimes not?
Well, many different things could cause it. But the important thing is that there are other treatments for urinary incontinence, and very few women would choose a product that could cause them perpetual pain for the rest of their lives over the alternatives that were available to treat urinary incontinence.
And from my experience, that seems to be the pattern with pharmaceutical companies. There'll be a product that's on the market that does a decent job, and then they'll look for like a Me Too product. Let's make something that does the same thing so we can get patent protection on it and we can sell it for a lot of money, because if it's generic, we can't make as much money. It's a little different with these kinds of, with medical device cases, but it's the same thing, just repeated drug after drug and device after device. That new product comes out, the manufacturers conceal the risks of the product, and then people suffer. And in this case, it's women who just wanted to fix urinary incontinence, and now they're stuck with pain and disfigurement for the rest of their lives. It's a very unfortunate situation. Do you have any comments about how you thought the oral argument went? I mean, did you have a good sense of you were going to win or lose after the hearing was over?
Based on the questions and comments the judges made, I had a feeling that we were probably going to prevail. Again, we thought we should have prevailed. We thought we should prevail on the law. We thought we should prevail on the facts based on the evidence that was before the court. You're always just kind of skeptical, and I think the lawyers who asked me to work on this were pessimistic just because, again, it was an MDL court order that was being appealed to Circuit Court of Appeals. And when you look historically at appeals of MDL decisions, you see far more decisions affirming or agreeing with the MDL court than you see reversing the MDL court. But based on the judge's questions, we thought, all of the lawyers present thought that we had a very good shot at winning. We thought we probably would.
One of the reasons I was so pleased to be able to bring Erik on as our lead attorney is, as I said, there's a number of firms that are involved in this, and firms reach out to us constantly to get Erik's assistance because he's really an excellent troubleshooter. If there's a legal issue and an appeal, he's one of the best people in the business to get on these cases. So it's so nice to have him in-house that we don't have to, reach out and try to make a deal. If we need him, he's here for us to help all of our clients, and your case will be in good hands if you choose to bring it to us. And Erik is very experienced in both state and federal litigation before trial and before appellate courts. He's really a great choice, and I hope you can get a sense of these are very delicate cases involving very sensitive issues, and Erik has a great deal of experience with treating people with dignity for injuries that are embarrassing to say the least. So if you'd like to have a consultation with either myself or with Erik, you could certainly reach out to us about your case. We may not be able to help you, but we will certainly give you whatever guidance that we can on if you have options. Unfortunately, the politicians keep trying to find ways to take these sorts of cases away. There's a bill pending right now that will be up for debate pretty quickly that will change the way MDLs work. And without getting into the specifics of it, if that bill had passed, then these cases would never even come into existence. Would you say that's right?
Well, it would be difficult for all. It's going to be difficult for all litigation if some of these bills pass. They're often passed under the nice-sounding name tort reform, but they're anything but reform. They are bills designed to take the judicial system away from injured consumers. That's all they are. They're designed to reserve the judicial system for companies fighting companies, but not for consumers seeking redress for injuries that are caused by some of these companies. So you can call them whatever you want. You can call them tort reform, but they're more tort disreform, if anything. They are designed to take the courts away from people who really need them.
And more than just taking the courts away from people who need them, it shifts a lot of costs onto taxpayers. Erik mentioned, a lot of these women are grandmothers and that they're old enough for Medicare. A lot of these revision surgeries are paid for by Medicare, by taxpayer dollars. And if these women are able to get a recovery, out of the money that they recover from these companies, they have to pay Medicare back for the surgeries. If these lawsuits never come through, there's no settlements, then it's just taxpayers paying to have surgeries for these defective products. Regardless of how you feel about lawsuits, certainly you have to agree that you break it, you bought it. And if the manufacturer is the reason that Medicare is spending millions or tens of millions of dollars on surgeries for these women, they should be the ones to have to pay it. That's part of the effort of tort reform, is to shift costs from the businesses onto taxpayers. I oppose that strongly, and I hope you'll consider opposing it as well. If you do any searches on the internet, you'll find how to contact your congressman. We'll have an area up on our website for that as well. It's something you should certainly look into to protect your rights, both as a taxpayer and as a citizen. Do you have any final comments about this case or any other appeals that are going on, Erik?
No, I just sincerely hope that everyone will, if you have a chance, contact your congressman about some of these bills that are designed to take the court system away from you, and tell them that you are going to be watching and that your vote will be contingent on how they vote in terms of your access to the courtroom. And if they make it more difficult for you to seek redress when you've been injured, you'll be making it a little more difficult for them to get reelected.
That's really the only way to make a difference if this is something that's important to you. I worked for a state senator for a while, and we did listen to the constituent phone calls. We did read the letters, and they did take it into consideration. I mean, realistically, if their largest campaign contributor says vote this way, and they get 6 letters saying vote the other way, you can figure out what they're going to do. But if those 6 letters turn into 60 or 600 or 6,000, it really will make a difference, regardless of how much money they get. If people know that people are passionate about these issues, if the politicians know. We'll be making a video probably next week about some of the terrible bills that are pending, both in federal Congress, and in the state of Texas. There's some bills too that are just designed, once again, to take away the rights of injured people and shift the costs that are going to exist away from the insurance companies and the companies that make defective products, and put them on the back of the taxpayers. That's not good for anybody, and we'll be discussing that next week. I'd just like to say again to Erik, congratulations for this great appeal, and I hope that the women involved are able to get good redress for their injuries. And if you're a firm that would be interested in having Erik work on an appeal, or if you're an injured person that would be interested in having him work on your case, please reach out to us. The website is Justinian.com, and the phone numbers, local and toll-free, will be there. Thank you very much for tuning in, and you'll see us again next week.